do not make handwritten notes on already executed will. Okay. A lot of times those are not enforceable, and they'll sometimes invalidate the whole thing. So just don't write on it. Don't go say, "Oh, change your mind. I want to do this." It's just not. Because that likely will not be carried out that way.
I want to add something after I've done it. It is all done. Can I write a piece of paper and attach it and say as of such and such?
Well, you can do a codicil if you're gonna do it. Is the original typed? I would type the codicil, have 2 witnesses, and have a notary to it, to the codicil, to include it. Okay. So in your will, you have usually nominate someone to be your executor. When you choose an executor, you're going to choose someone who is competent. You're going to choose someone who's trustworthy, who's going to carry out your wishes with regards to your estate under, per your will. And someone who's willing, who's able to serve. It's a pain to be an executor. I think a lot of people think it's kind of a glamorous title to be an executor of an estate, like, oh, I'm the executor, But it's really just a pain. I don't know how many of y'all have ever served as executor or know someone that has. It's this long, drawn-out process. You have to file all these things with the court, and there's nothing glamorous about it. And I'll talk about this. I think my probate slide may be next. Yes. So the probate process. When I was growing up, before I went to law school, I always thought that everybody who had a will had an executor. It's just what happened. Someone goes to the courthouse, qualifies on the estate. Everybody you have to have an executor. Well, that's not the case. So there's one way of doing it, which is called probating a will without qualifying. Because Virginia law in most states do not require an executor to go qualify. So if you say in your will, I want my daughter to be my executor of my estate, when you pass away, she doesn't automatically become the executor. A lot of people think that's how it doesn't work that way. There's another step. She is the named executor. She actually would have to go to the courthouse with the probate clerk and qualify and take an oath to carry out your wishes under your will, to pay off any creditors before making any distributions to the heirs and to the beneficiaries. So she's the named executor, but she's not the executor until she goes and qualifies. And that step is not required. That is only necessary if there are assets that you can't get to in the estate. That's the only time. I'm named executor on one of my client's estates because she just passed away, and her kids were kind of young. And I'm not qualified because there's no money. Everything she had a beneficiary name, like a life insurance policy or a bank account. There was a beneficiary designation on that. And so there's every asset she had I can get to without having to go through the trouble of qualifying as executor. Does that make sense? And the same goes for people without a will. If you can get to everything in their estate, either they were joint accounts or they have beneficiary designations, you don't have to go qualify as administrator. And when you go qualify as administrator or executor, you're agreeing to pay off any of their debts first. But if you name somebody on your account, like as a beneficiary of your bank account, they have no legal obligation to use that money to pay off your debts. So just word of advice, if someone passes away, don't go run to the courthouse to qualify as executor. Figure out what's in the estate. Do I need to go qualify to get to it? And what creditors are out there? Because if there's $50,000 in the estate and $50,000 of the creditors, does it make sense to go qualify just to pay off those creditors? So people a lot of times will run to the courthouse to qualify or start writing checks to pay off the creditors and realize later that they would not have been the best thing to do. When you write a will does not govern everything you have. A will only governs assets that are probate assets. So assets that don't have a beneficiary name, that are not joint. A lot of people have joint accounts with right of survivorship, right? You may own it with your spouse, and if your spouse passes away first, the other spouse gets everything in the account, that is not a probate asset. That's a non-probate asset, because your will, you could say in your will, I want my son to get that money. That's not going to matter, because on the account you may have someone else named as joint owner with right of survivorship. So they'll get it. Does that make sense to everybody? Other assets like life insurance, you name a beneficiary. Okay? You can't go write in your will, I want my son to get my life insurance if your daughter's name is beneficiary, because that's going to trump what happens to that asset. Also, a lot of people, and I didn't know this until a few years ago, on your bank accounts, on your 401ks, on your stocks, you can name a beneficiary. Are y'all aware of that? It's called a payable on death beneficiary designation form. You walk in, or you call the stockbroker, you say, I want this form. Sometimes it's called transfer on death, especially if it's a stock or something. And you name who you want to receive that at your passing. You can name a primary beneficiary, you can name a contingent beneficiary, and that way, if something happened to you, all they have to do is mail the death certificate to that financial institution, and the money is paid out right to them. You can do that on your car. The DMV, they passed a law last year saying you can even do that with your car if you wanted to. So a lot of things that people will do a little planning up front, you can avoid having to even go through probate later if you start naming beneficiaries on all your accounts. And if you change your mind, you just go in and you redo the form. Do you have any questions about that? So these are types of non-probate assets, joint accounts, and right of survivorship. Banks have gotten into the habit of, when you go in, you say, I want to add my daughter to my bank account, because I want her to be able to write checks and help me if I get in a bind and I can't handle my affairs. Most bank personnel will not ask you, do you want that account joint with survivorship or joint with act? And they're very different things. So I have a client, she went to the bank when she was 103 and added her daughter to her account. Well, she had 6 other kids, but added her daughter to the account so her daughter could help her. When the lady passed away at 107, the woman who set up the account at the bank set it up joint with right of survivorship. So everything that woman owned went to that one daughter. Now, a lot of times that happens with people, with my clients, and they're sweet and they'll split it up because they know that's what the mom would have wanted. In that case, we're in court trying to get the daughter to give it back. So when you do, if you do, I'm not a fan of joint accounts because I think people just don't really sometimes realize what they're doing. They might be favoring one child as far as leaving one a bigger inheritance than the others. Also, if my mom said to me, Joley, I want to add your name to my account, I'd be like, no, I have a power of attorney, that's sufficient. If she adds me to her account, and if I had to file bankruptcy, or if I had a big creditor, that exposes her money to my debt, to my creditors. And there's just no need for that. There are other ways to just do a power of attorney. And then the person can help you with your finances without there being any risk like that. In real estate, typically if you buy a property with someone else, a lot of times the deed is written joint with right of survivorship. If you buy property and you're married, it's tenancy by the entirety, is how they call it in Virginia, but it's with right of survivorship. So I have a couple who own a property. I've had to do this a couple of times where husband and wife own a house, but when wife passes, we don't want husband to get it because he's on benefits of some kind. So I've got to redo the deed to make it without right of survivorship so that she can leave it to someone else in her will. So these are just all things to be aware of. So
husband and wife are married.
Husband and wife are married.
50 years.
50 years.
1 year.
It makes no difference. If you buy a property and you're married, the deed is written tenancy by the entirety, normally. And that implies right of survivorship. So if wife said, but I want to leave my interest in the house to our son, she can't do it because if something happens to her, it's going to go to her husband. So we just rewrite the deed to say without right of survivorship.
Is your husband aware of it?
Oh yeah, he has to agree to it. The reason he has to agree to it is because he's an owner in the property, and we're changing how the property is titled. So yes.
When you get benefits, you already have it on record that you have conditions in the house.
Right.
Why?
And transfers between spouses are exempt for benefits. So if we transferred it all into, I had a lady who I got on Medicaid last year, and then her husband was fine, he was out and about in the community, and because for Medicaid, and it's decided transfers between spouses are okay, we just transfer it to the husband's name.
And bank account, as you mentioned earlier, the rights of ownership, it sounds to me like that almost invalidates the will. Is that not misunderstand or what?
They're two different things. The will just doesn't, if I have a bank account at Wells Fargo, and I have someone else named as joint owner with right of survivorship, my will does not control how that money goes when I die. Because whoever's the joint account holder gets the money.
But the person who's joint account holder only gets the money that's in that account.
In that account. Right.
Thank you.
Right. The only account that their name is on. A lot of times I'll have clients who have second marriages, and all they have, everything is jointly titled. So then, the surviving spouse gets everything, and the kids from the prior marriage don't, because they're non-probate assets. They're real estate and bank accounts. And people, people just don't really either think about it, or they just think everything's going to go one way, and a lot of times will go differently in the family, not what the family thought. And my job as an owner law attorney is to think of every scenario possible and to make sure people understand what will happen in these types of scenarios, to their estate, and what do they want to happen, who do they want to include. Yes.
Do you have to do that before the person is on Medicaid, or can you know how, like, if you're going to have to put somebody in a nursing home and you've got assets that would need to be split up, do you have to have what you're saying needs to be done prior to applying for Medicaid?
No, it does not have to be done prior. Typically, especially with real estate, with Medicaid, real estate is exempt for 6 months, the principal residence is. There are lots of loopholes for real estate in Medicaid. And then for assets, a spouse can keep so much liquid assets.
Right.
Typically, individuals who have non-exempt assets, there's a 3-month grace period once they get on Medicaid to move things around out of their name. Medicaid. Medicare doesn't care what you have. Medicare is you earned that benefit. Medicaid is an entitlement that you have to, it's means tested. So yeah, Medicare doesn't care.